Great. And next, I'm going to pass it to Jihan, who's going to talk to us a little bit about all of the different kinds of testimony we can expect.
Thank you, Sine. As I mentioned, testimony looks different for absolutely everyone. And as we're coming in as a state level advocacy organization, our perspective comes from a very systematic level. But when it comes to shaping policy, no single voice paints the whole picture. It takes the whole gallery, from researchers who bring the data and the numbers and the proof, quote unquote, to advocates who connect the dots and really add color to the picture. Survivors who add in the most important part, the lived experience, the raw truth, the texture that makes the story feel so real. To community members, there's so many actors that create the picture we're trying to paint as a collective. Everyone comes from a different perspective, so speak from your experience, as everything that you share is completely valid and adds to the beautiful painting we're trying to create. So testimony from someone who's personally impacted will look very different from testimony of a researcher. And again, it's all intentional to get our point across in the most varied and specific way.
Thanks, Jihan. So next, we're going to get into talking a little bit about the differences between the two kinds of testimony. So written testimony, and oral testimony. So we're going to start with written testimony. So this is a really great way to still show either your support or not in support of a bill, even if you can't make it to the physical hearing. And yeah, so this is a really great way to still show your support or lack thereof. And so when when you're doing written testimony, important things are you're going to want to include the bill number, the title of the bill. So for example, for the abusive litigation bill, I don't have the numbers exactly right off the top of my head, but the title would be an act relative to controlling or abusive litigation. And then also you want to include your name and also your affiliation if you work with survivors or share your credentials to the extent that you feel comfortable. Something also that's important, and it has a little bit of an asterisk, is that you're going to want to submit your written testimony by the hearing date. And so why this has an asterisk, well, it is very important to do your best to get it in before the hearing. I do know that there's a little bit of flexibility with that. So I've heard people say to try to just get it in with like within 10 days after the hearing. So if you're not able to do it before the hearing, just make sure you try to get it in as soon as possible after the fact. Like I said, there is a little bit of flexibility, but we just really want to make sure that all of your voices are heard and what you have to say is taken into consideration. And so, yeah, just really important to get that in as soon as possible. You'll also want to introduce in your written testimony, you're going to want to introduce yourself and your organization and clearly state your support and opposition for the bill. And in doing this, you're also going to want to include the why. So why do you support this bill? Why do you not support this bill? I said it before, but you're really going to want to share the stories and statistics and numbers. Like I said, legislators really, really want to hear stories from survivors. They want to hear stories from direct service advocates and providers. And so it's really important to, in your written testimony, share the why and the stories and those statistics. And it can really just make such a big difference in your testimony. I don't know if Nithya, you have anything to add on that front.
I think the other thing to just emphasize, we'll talk a little bit about the oral testimony in a second, but like this is kind of the place, there's no like limit to how much you can include or can't. Because oral testimony is limited by time, this is kind of where if you are testifying orally, you can use this kind of in addition to that. If you're just writing things written, like you have all of the space you can to talk about your experiences, either personal experiences, survivorship, your professional experience, and if you're a researcher, like having those statistics and like really, if you're more in depth and have in-depth knowledge about a certain bill, then you kind of comment there around specific parts of the bill. So this is kind of where you have space to talk as much as you want.
Thank you. So next we're going to move on to, like Nithya was saying, oral testimony. And so, yeah, this is testimony that you just give in person or via Zoom. And so that's what we're going to start with. So oral testimony can either be delivered in person or virtually. The legislature follows a hybrid format. So which makes it really easy for folks to, if they can't be there in person. I know Boston is kind of a trek for a lot of people, including myself. So having this Zoom option just really makes it that much more accessible to folks who might not be able to get to the State House, especially on such short notice. An important thing to know about coming in person is that if you join us in person, which we highly, highly recommend that you come with us in person on Tuesday or in the future for other hearings, you might not know exactly when you're going to get called up to give your testimony. So when you're going to hearings, it's not like they give you a list of like the order of operations for the day. We're not really given like, oh, you're going to go first, you're going to go second, you're going to go third, etc. So you might not know when you're going to be called up. So that's why Nithya was saying earlier, like you can expect to be there for a while, especially if you're in person. And so, yeah, just know that we will be there to support you in the hearing. We'll be there as long as you all are. And we're really there to just provide that support. The next important piece of oral testimony, and Nithya kind of alluded to it, is to keep it short and simple. So in the written testimony, that's the place where you can really like say as much as you want. And the oral testimony, again, is where you're kind of limited to that time limit. So you're going to be limited to about 2 to 3 minutes while testifying. I would err on the caution of shorter. And when you're giving your oral testimony, make sure to greet the committee, state your name, where you live, your affiliation, say you either support or oppose a bill, add the why, and end with the ask and a thank you. So I know that's a lot, and Nithya is going to take us through a really great example later to kind of show us like this is what testimony can look like, things like that. But yeah, really important to make sure you greet the committee, introduce yourself. I think like Nithya was saying, just kind of show that connection to the bill. And then say like, this is why I support this. This is why I do not support this. And then end with the ask. So, and Nithya, I'm sure we'll talk about this later, but the ask to, report the bill favorably from committee. And then finally, share your story. So like we've been saying, you've heard me say it a million times already, but stories are the most important. Your stories are the most important part of your testimony. So if you're comfortable, use that to your advantage. Share your personal story and experience with the legislature. Like I said, you're the experts of your experiences. You're the expert in the room. And they want to hear from you. They want to hear your expertise. They want to learn from you. And so to the extent that you're comfortable and that you feel safe to, and we're going to go into that a little bit more in the next slide, really just recommend sharing your personal story and experience with the legislature. And I don't know if Nithya, you have anything you want to add to the oral stuff? No? Cool. Well, I'm passing it to you anyways, because we're going to be talking a little bit about privacy and confidentiality considerations when testifying.
Thanks, Sine. I think something that's really important to consider before you testify is your own personal safety and considerations of what it means to kind of, talk about your story. And for some, for folks who have, are talking about past experience might feel more comfortable sharing their stories. Some folks who might be currently living in a situation might not. So just the bottom line with any sort of testimony, like your comfort, safety, and privacy needs all come above all else. That being said, there are ways we can try to like mitigate some impacts of what it means to reveal some personal information. The one thing we definitely recommend, like while oral, like I think Sine mentioned this, but like while you are testifying orally, is to kind of limit any sort of personal identifying information. Like for example, like if you are talking about a specific experience at a specific court, avoid naming that court, avoid naming any an ex-partner, avoid naming people you've worked with. Just keep that as general as possible. So technically the only personal identifying information you should be sharing, if you feel comfortable, is your name. And if you are an advocate, if you're like talking about your expertise, then where you work, for example, that is all. Or if you feel comfortable, you can mention city or town, but I would avoid any sort of specific identifying information like a court or a school or names of children, for example. So when you, like I mentioned a little bit earlier, if like a standard person who is testifying, hearings are live streamed, so people can see who is testifying. People can access that later. So it'll be available for those who want to find it and post it on the State House website. This is obviously, as proponent of transparency, this can be very helpful for people to actually understand like what's going on. For folks who have privacy concerns, this can be challenging. The legislature in the past has taken measures to protect a person's safety while testifying. Last year, or the hearing that we had last session for this bill on abusive litigation and another bill on coercive control, we were able to have folks, if they wanted to just use pseudonyms instead of their actual name. We communicated in advance with the chairs to kind of stop video or recording when somebody was testifying, so that's not on public record. So there are ways. We just need to know in advance and coordinate that with the legislature. Also the other thing to consider is like if even showing up in person can be challenging for somebody, that there is that virtual option, right? And there's also the written testimony option that you can also consider. So the bottom line is everybody's needs. You need to kind of make your own safety assessment. If you are working with an advocate, work with them. If you're an advocate who is working with a survivor, then as you are working on safety planning, then this could be something to consider. It's always just wanted all of you to know that it's really, really important for folks to hear your story, but you need to be comfortable and feel safe in order to do so. So yeah, like let the focus be on you, your experience, why this change needs to happen, and kind of limit the details as much as possible. Thank you.
And I think it stays with you. So yeah, I'll give it back to you.
All right. So I know folks probably have a lot of questions on this specific bill, so happy to answer that towards the end. Yeah, so hearing next Tuesday at 1 p.m. It's in room A1, which is the first level of the House, or the State House. And basically the bill is on an act relative to controlling and abusive litigation. The lead sponsors are Rep. Blay and Senator Moore. This bill essentially gives Massachusetts courts the authority and tools to identify and stop controlling and abusive litigation. So that's when somebody abuses the court system and repeatedly tries to continue to abuse or harass a survivor by bringing constant suits. So if this were passed, a survivor would be able to request an order restricting controlling and abusive litigation. So it's just a form of relief to protect survivors from further harm, but it also emphasis is that it still preserves access to the courts for everyone. Next slide, please. So I think something to, when you're talking about testimony, when you're giving testimony, either written or virtual, like the experience of your story. So either your personal story, if you're an advocate, why maybe you've seen this before, maybe the concept is something that you want to talk about. Even, something to emphasize that even after leaving an abusive litigation, survivors are often forced back into court over and over by the person who caused them harm. And it can be financially, emotionally, and physically draining. And we've heard stories of just the immense cost of what it means to be dragged into court. Also, that there's also extenuating costs like transportation, childcare, right? So, just emphasizing like those details, because that's part of what the bill does, is that survivors will be able to kind of seek that relief as well, financial relief as well, if this bill were to be passed. And just, noting if you are, a family member or a friend of a survivor, just noting that family and anybody can be, traumatized by this pattern of abuse. If you're an advocate, kind of seeing this at play constantly, right? So any sort of details of how this sort of bill kind of has impacted you emotionally, impacted you professionally, financially, all of those details are really relevant. I see in the chat, this bill protects survivors in district court and or probate and family court. Both would be the answer. So it's in any civil context. Next slide, please. So when you are thinking about what your oral or written testimony would look like, something to remember the details that Sine mentioned earlier of what to include in your testimony. If you are an advocate, if you're a director of a program, talk about what your program, what you see as a DV or SA agency or DV agency, how you've supported survivors through this. If you are an attorney, I think that legal experience and expertise is really welcome as well. If you have an anonymized story that you want to share, you can do so. So this example is one survivor we worked with was taken to court over a dozen times, causing them to lose income, miss medical appointments, experience serious emotional distress. So if you can, share a story like that, if you're an advocate, that could be very impactful. And then just kind of the impact on programs for what it means to kind of, spend attention on supporting a survivor through repeated court actions. And just really making sure that or talking about what could happen if this part of the system was fixed and survivors had protection against these abusive measures. So there are tons of paths you can take with how you write or talk about your experience. Any experience is helpful. Even if you have, honestly, even if you have not much to say, if you can't take up the 2 minutes, if you can't take up a whole, a few paragraphs of written testimony, just saying that you support the bill for one reason, that's helpful, because that's still in the record that somebody supports this bill. So whatever you can share, whatever you feel comfortable sharing, please do. Even if you don't want to share all of the information, that's still also helpful. So I think if there are, I think that's a good comment from Palma in the chat. One other way to use these hearings is to use those notes or speak directly off the record with your rep or senator. So basically, if you don't feel comfortable testifying at the hearing, you can then have a conversation with your own rep to talk about it, maybe personally, and then they can kind of support in that way. So there are plenty of opportunities. The thing is now with hearings is that the new rules mean that it's we're in a tight period of advocacy. Any House bill has to be reported out of the committee, which means go to the next step within 60 days of the bill being heard. The Senate has different rules, and their reporting deadline is in December. So it makes things a little bit confusing about which way they'll go, but we are really emphasizing the 60 days here. So after you testify, then a great thing to do is to follow up with your rep and tell them that you testified on this bill and you want them to co-sponsor and support this bill and advocate for it to be reported out. Another thing you can do is, if you don't feel comfortable like, again, like if you've shared your story, or if you want to share your story with a rep and you don't feel personally comfortable testifying in this way, you can ask them to submit written testimony or testify kind of on behalf of you. So basically they would probably just anonymize your story and say that a constituent said this. So another thing you can do is just talk to your rep about supporting a bill. So again, there are multiple avenues you can take. It all depends on your comfort, what you're willing to share. With this specific, so we literally just got the notice. Sine, are there more slides after this, or should I talk more about this?
Go ahead.
Okay.
Go for it.
Basically, yeah, we can put in the chat later the link to find your rep. I don't know if Jihan, are you able to pull that link up and put in the chat? Great, thank you. So I'm gonna share with you all. This is I will put this in a second, but yeah, so we just received a hearing notice for this bill. So that's like the official notice from the committee. And this notice, this is kind of where you register to testify. And I think the deadline to register for this hearing, if you're testifying virtually, is at 5 p.m. on Sunday, which kind of is complicated. This is very new, so I'm trying to still figure out how to navigate this, is that they have now are requiring people to create an account to testify. They have never done this before. I think that makes things a little bit difficult for coordination of folks who want to testify anonymously or use a pseudonym and don't want to reveal information. I'm going to try to contact the committee to see if there are any workarounds around this. But if people who feel comfortable to testify, definitely encourage folks to make an account and sign up. We also have an internal form that I just put in the chat. This is kind of for us to take note of who is testifying so we can coordinate. For example, if you want to share just a pseudonym, if you have any, constraints around if you don't want to be recorded, you can mark that, put that note in the form, and we will try to, figure out accommodations with the committee, but we'll be in contact with you. So that's for our internal purposes, but we also ask that you register there and also on the state website. If we can figure out a workaround around this for people to not have to make an account, we will try to do that. I know it's pretty limiting and it's pretty new. I've never seen them do this before, so we're still trying to figure out those kinks there. But if folks can fill out this form, if you are willing and open to testify, when will we find out about the state website? The website is up. This is the link to the hearing. 1 second. Oh, did I send you the wrong? I might have put the wrong link in the chat here. This should be. I don't know why it's. Okay, I just updated the privacy settings, so everybody should be able to access the form now. Yeah, I see the comment around concern about tracking who is testifying. I'm also pretty concerned about that. Again, this literally just was posted like less than an hour ago.
Like 40 minutes ago.
Yeah, like right before this. So we didn't have enough time to figure out those logistics before. But we will try to figure that out and have an update to folks who are, at least if you're part of TREC, if you're a JDI member, we will have updates for you all on what we think around that, because I'm a little bit concerned and annoyed that this is happening. Question around, can organizations have one account that folks who are testifying on a bill can use, or does every person who testifies need their own account? From my understanding, it looks like you can only have one person from how this is structured. I am not sure yet. I think that it looks like you can only register one person, which is my other thought was I would just make an account for JDI and just register everybody, but I don't think I'm able to do that. So I will follow up with that if we have a better answer. I'm sorry, I don't have a better answer for you, but if there is somebody who wants to right now test that out, I will welcome that. But I think from my impression, it seems like that's not possible.
And it seems like we're getting into like the questions portion of everything, which is great. So I'm just going to go ahead and stop the recording so folks can ask their questions freely.